Thank you. Thank you all for coming and for watching on the live stream. Today we're going to talk about understanding workplace harassment laws. Recently you've all heard of Me Too, right? Harvey Weinstein, Bill O'Reilly, Al Franken, Matt Lauer, Charlie Deloitte, Mario Batali. These are all just a list of the names that have recently been involved or had sexual abuse scandals and harassment brought against them. You know, outside of the spotlight, the Me Too movement is millions of women coming forward and posting and sharing their stories under the hashtag Me Too. So in 2017, October 2017, NBC News put out a poll that said 48% of women in the workplace have experienced unwelcome sexual advances or verbal or physical harassment at the workplace. Think about that. 50% of women. Compare that to what the EEOC statistic is, that 10% have actually filed a formal complaint. What that tells you is that right now, this is something that we all need to be addressing and doing better at in the workplace. You know, we need to make sure that the culture is changing so that half of our workforce isn't feeling uncomfortable on a daily basis. So what constitutes illegal workplace harassment? Most of you have heard of Title VII of the Civil Rights Act of 1964. It prohibits discrimination on the basis of race, color, religion, sex, pregnancy, national origin, and it applies to both your applicants and your current employees. Sexual harassment, as that term we know in today's society, is actually a form of discrimination under Title VII. It's gender discrimination, sex discrimination. So some of you are going to see that Title VII only applies to employers with 15 or more employees, and you think, oh, it's not going to apply to my company. Well, Pennsylvania Human Relations Act applies to employers with 4 or more. And regardless of whether or not either one of these applies to you, it is good practice to make sure that this is not happening in your workplace, okay? So what is harassment? Unwelcome verbal or physical conduct motivated by an individual's membership in a protected class, and either submission to or rejection of such conduct by an individual is used as the basis for an employment decision affecting such individual, or the conduct that is sufficiently severe or persuasive to create a hostile work environment for a reasonable person in the complainant's circumstances. Remember, some of these terms are bolded. Remember reasonable person. We're going to talk about them a little bit more, but this is just the basic, right? And in this instance, when we're talking about sexual harassment, the membership in a protected class, that's going to be your gender, your sex. So what are the types of harassment when it comes to sexual harassment? Typically recognized, there's 2 forms of it: quid pro quo and hostile environment. So quid pro quo is benefits of employment conditioned on employees' submission to or rejection of supervisors' sexual advances. This is the example that most people would think of: sleep with me or ruin your career. Sleep with me and you'll receive a promotion. But what you don't think of is, go out with me and maybe I'll give you a better shift assignment. You want to move from 3rd shift to 1st shift? Or give me your phone number and maybe I'll let you take that day off work later. It doesn't have to be the extreme nature. It's any benefit. And we'll get into what a supervisor is later and whether or not other employees who aren't your supervisor can be involved. But that's the basics of quid pro quo. For the hostile work environment, is discriminatory intimidation, ridicule, and insults, which is sufficiently severe or persuasive to alter the conditions of the victim's employment. Examples of this are comments, jokes, graffiti, sexual advances and remarks, touching, questionable compliments, pornography, offensive or verbal conduct relating to one's sex, right? It's where it's so pervasive in the workplace that it makes them uncomfortable. So what are your elements of a hostile work environment? Conduct must be unwelcome. Conduct must be based on an employee's protected characteristics. So when it comes to gender discrimination or sexual harassment, it doesn't have to be sexually explicit, right? The protected characteristic. It just has to be directed at the gender and motivated by discriminatory animus, right? So I could be treating all women or all men differently. I could have a bias towards women in the workplace. I could have a bias towards men in the workplace. It doesn't have to be the sexual objectification or sexual nature. It just has to be my discriminatory basis on your gender. Conduct must be severe or pervasive, and conduct must unreasonably interfere with an employee's working conditions. So what's unwelcome? Hard term to define, but the unwelcome nature of conduct is generally determined by examining the complaining party's response. So it means you're going to look at each situation differently. You're going to look at how the people respond. You're going to see what's happening, right? So it may be unwelcome if they tell the individual, hey, I don't like that. You know, they may not come out directly to that individual, but they may come to your HR. They may come to others. They may ask for a change in workplace without saying why. You know, unwelcome is an amorphous term, but when you see it, you'll know it, right? Similar to how the Supreme Court defines pornography. I don't know what it is, but when I see it, I know it. You know, you always have to look at it in the scenario, but remember that it's from the individual's perspective of whether or not it's unwelcome and not from the harassers or others around them. It's how they perceive it. And I think the thing to remember here is, you know, some people may say, well, in this type of environment, whether it's the shop, a garage, warehouse, this banter or talk is welcome, it's normal. Remember that that's not a defense. It's from the individual's perspective. So regardless of what environment they're in, it's their perspective that they're bringing to it of whether or not it's welcome or unwelcome. So when is conduct severe and pervasive? Severe conduct is that conduct that is so objectionably offensive as to alter the conditions of an individual's employment. It's not isolated comments. It's not simple teasing or an offhanded comment. So I'll give you two hypotheticals. Billy, the supervisor, is passing and only once calls Alice an accounting babe. Should that be done in the workplace? No. But is that so severe as to rise to the level legally of sexual harassment? Probably not. How about if Billy goes to Alice's desk and then starts describing his sexual conquest from the night before and insinuating to Alice that she could have a similar night? Now we're getting into a scenario that's never appropriate and is very much severe in nature. You're getting from a single isolated off chance comment that doesn't have any follow-up to it to something that is outside the bounds of what you would normally see. Pervasive. That's conduct that's repeated, routine, or generalized offensive conduct that it so permeates the workplace as to alter terms and conditions of employment. So Billy's supervisor nicknames Joe employee princess. He then makes comments about Joe's feminine nature and sexual orientation. Other employees start calling Joe princess and start making similar comments. Now you have repeated, you have routine, you have generalized offensive conduct. These are the things that you're going to see for pervasive. It's worked from one person to multiple people. It's a culture now that is going on throughout your entire workforce that many people are treating the same individual in the same way. Okay? So what are your typical types of behavior that's going to deem sexual harassment? Sexual innuendos and comments, sexually suggestive sounds or gestures, repeatedly asking a person out on a date, ogling or leering, staring at someone, rating sexuality, pornography, touching. And touching can actually be a crime as well. And even, you know, someone who say that it's only minor contact or an accidental contact, you know, that may not be criminal action, but that could still be sexual harassment. You know, just because it's a passing glance doesn't mean that it's not objectionable, and it doesn't mean from their perspective that it isn't something that is harassment. Degrading or demeaning comments, repeated discussions on sexual topics. Other things can fit in here, but these are the general types of things you're going to see or that will be deemed. So actions and perspectives. Bad behavior applies to physical, verbal, and nonverbal actions, right? Think about nonverbal actions, right? So that's gestures, it's eye contact, that's the ogling, that's the staring. Just because you're not verbalizing or making a physical aggression doesn't mean that the contact itself can't rise to the level of bad behavior or actionable behavior. And important in today's world is remember that this applies to electronic communications. I like to remind people, if you wouldn't say it to someone in the workplace, do not say it over social media. Just because you do it over social media, just because you do it over email, just because you don't do it face-to-face does not mean that that conduct is not harassing. Doesn't mean that that conduct doesn't discriminate on the basis of gender or religion or race, whatever it may be. Another one to remember is intentions do not matter if the person feels harassed. So you focus on the impact of the behavior, not on the intent of the person. So many people are going to react differently. What is appropriate interactions with one person is not going to be the same appropriate interactions with everyone. And you need to take that in consideration, because when the courts look at it, it's going to be what a reasonable person finds to be appropriate, right? And if a reasonable person in their shoes determines or would find that conduct to be harassing in nature or pervasive or severe, that's what we're going to be looking at, not what your intent was. I didn't mean to offend them. I didn't mean anything by that. I didn't mean to keep asking them out. I thought they were interested. Well, if they indicate that that's not wanted or unwelcome, you got to change your behavior. Locations. It's not just at work, people. It's at company functions and social events. Many of you come to chamber events together. It could be there. Non-work events with coworkers. Just because you're outside the workplace does not mean that your conduct can't be considered sexual harassment for the workplace, right? Especially when it's a supervisor. Just because a supervisor and a coworker are out or traveling doesn't mean it gives them free rein to act however they want to act. You still have to remember that your behavior can be tied back to your employment and can create liability for you and your employer for that. Same sex. Without getting into the politics of it, most courts are now looking at sexual harassment as gender neutral. So when you think of it, the typical scenario and the ones that I've been giving have been men harassing women. But it can be any way. Men harassing men, women harassing women, women harassing men. Title VII prohibits discrimination on the basis of sex and protects both men and women. And so it should be reviewed regardless of the harasser's or victim's gender or sexual desire. And sexual desire is another thing to remember, right? You cannot use as a defense that's something that they wanted, or that I wasn't attracted to that person, so how could I have sexually harassed them? That's immaterial for this discussion. And again, without getting into the politics, I'll just tell you that litigation involving sexual orientation and transgender status is occurring. I would tell you that the best practice is to assume that these are protected characteristics. You're seeing the trend, the EEOC is moving this way, that they are protected characteristics. And I would be hard-pressed to stand up in court and argue that I didn't discriminate based on gender, I just discriminated based upon transgender status. It's a very fine distinction, and I don't think that it's going to be around. Your best practice is to assume that if it's based on transgender or sexual orientation, to just treat it the same way as you would be treating it if it was just the typical male harassing a female. Besides Title VII, here are some other